here to introduce your speakers, and then they're going to take it away. So I'm going to introduce myself first. My name's Paula Savchenko. I'm an attorney with Maffa, Satin, and Daneni. We do regulatory compliance and tax planning. So this is actually a great panel for me to go ahead and introduce to you guys. First, you have Rachel Gillette. She's partner and chair of the Cannabis Law Practice with Greenspoon Marder. She's standing right here next to me, and she's going to be your moderator today. Then we have Dana Chavez, Senior Vice President and Director of Specialty Banking Relations for First Federal Bank of Florida. And then right next to me here, we have James B. Mann, is a partner with the Tax Practice Group at Greenspoon Marder. These guys are going to speak to you about accounting for cannabis and the IRS. Enjoy.
Hello, everybody. How was lunch? Everybody enjoyed it? It was really good, wasn't it? One of the interesting things about the cannabis industry, we have all these anomalies. One of the anomalies of cannabis when it comes to banking and accounting is that it's actually quite interesting because we have 280E and we have a number of challenges in the banking arena, which my guests will speak more about during this presentation. So I'm going to start with Dana. First of all, do you want to expand a little bit on your background and kind of how you've gotten into this industry?
Sure. I got my start in banking in the cannabis industry in Colorado roughly over 5 years ago with a credit union that has literally wrote the book on banking and cannabis. And from there, I went to a payroll company for their banking relations, and I served as the Banking Access Committee chairman for the National Cannabis Industry Association, where I co-authored white papers on educating financial institutions on starting a compliant banking program, as well as educating business owners on what to do in order to be banked and maintain a banking account. I've also lobbied on the Hill on behalf of banking and lending rights in the industry. In June, I gave congressional testimony at a hearing for the House Small Business Committee for wording on the SBA to change it to include lending and banking for cannabis and CBD and hemp.
Wonderful. James, do you want to give a little bit more about your background?
Sure. I'm just a boring corporate tax lawyer. I have a normal, boring corporate tax background. I went to Harvard Law School. I have an MBA from Columbia. I was in private practice, but in DC I was also a Deputy Assistant Attorney General of the Tax Division of the Department of Justice in charge of federal appellate tax litigation. In addition to private practice, I've worked doing tax stuff at banks like Goldman Sachs, and now, thanks to Greenspoon Marder, I'm in cannabis tax, so I'll just stop there.
All right, great. So, Dana, how many banks are actually serving the industry? And I want to say that I think Florida might be different than some other states, because Florida has limited licensing. So I'm going to venture to guess that most of the marijuana businesses here do hold bank accounts, and they are banked. But in a state like Colorado, where there's thousands of licenses, we're not unbanked, but the industry is underbanked. And there are still a number of businesses, we have thousands of licensees that simply cannot get bank accounts. So it remains a challenge. So I'd kind of like to know how many banks are actually servicing this space, and then why aren't more banks doing it?
Well, you'll read articles that say there are roughly anywhere from 400 to 500 banks banking the industry, but that's untrue. There are roughly under 50 banks in the United States that are knowingly and willingly have an open cannabis banking program. The rest are banking cannabis money, but they just don't know it or they're turning an eye to it. And the reason banks do not get into this industry is because of the complexities for the compliance structure and the resources involved that it takes to monitor these accounts, do the due diligence, and definitely the high risk involved.
So I have a question about the hemp industry, because hemp is now legal in all 50 states, although there are some challenges, which I'm sure you'll hear about later. What about banking for hemp in particular? Are there more banks offering services? Are they taking their time getting into the space?
The trend is that a lot of banks that have a cannabis banking program are not focusing on the CBD and hemp because they'd rather focus on the cannabis side. Other financial institutions, they start out with a CBD and hemp banking program, but then they realize that it requires a lot more compliance and due diligence than they were expecting, so they drop it. It's just a matter of educating and knowing the difference between the CBD and hemp plant versus the cannabis plant.
So one of the things that I come across, because I work with plant-touching cannabis businesses, licensed businesses, but also ancillary companies that might provide a service to the cannabis industry, or they might be a landlord that's receiving funds from the cannabis industry. And you hear sort of a lot of talk about tier 1, tier 2, tier 3 cannabis businesses. And some of our audience might not know the difference in the banking lingo of what those things are. So maybe you could educate us.
A tier 1 level banking relationship are funds that go into the account from the daily sale, transportation, or anything to do with the plant, a plant-touching business. An ancillary, tier 2 would be an ancillary or a depository account, or even an investment account, or a place to house your capital raise funds. Tier 3 is a little bit further removed, such as a doctor's office that prescribes the medical marijuana card.
Okay, so the tier 3 might not be receiving cannabis money at all, or any money from the sale of cannabis, but they're affiliated somehow.
Correct.
So are there more banks willing to bank the tier 2 and tier 3s, or are they still going to have the same compliancy program?
I get calls every day from businesses that have lost their account because of their name or something in the media or on the internet that associates them with the cannabis industry.
Right. So obviously, if you do have a cannabis business and you have an account, there are significant fees associated with those accounts. And I think that's probably because it's a challenge for the banks to have a compliancy program. But ironically enough, those fees are also, at least in audits of marijuana businesses, the IRS is disallowing those fees under IRC 280E. So James, I'm pretty sure most of our audience might know about 280E, but would you like to give a little primer, just in case there might be somebody who doesn't understand what it is?
Sure. To begin with, generally speaking, the tax law seeks to tax income from whatever source derived. They don't care how you made it. They just want to tax it. And 280E was enacted in response to a tax court case where a drug dealer wanted to deduct the cost of his scales and his car and his home office for selling coke. And the IRS said, no, you can't deduct those expenses because it's illegal. And the tax court said to the IRS, what are you talking about? You get to deduct the cost of your businesses, no matter whether it's against the law or not. This tax court case was in 1982, and so just say no, and Congress got outraged. Congress passed this law in 1982 saying, you do not get to deduct any business expenses if you traffic in a Schedule I or Schedule II controlled substance. Schedule I includes cannabis and heroin, right? They're both alike. And that's this weird anomaly in the tax code, because like if I'm a blackmailer, I get to deduct the cost of, my private jet and the island and all that stuff. But if I'm a dispensary selling medical cannabis, I don't get to deduct any of my expenses. So that's what 280E is. And the IRS has won like 6 tax court cases in a row about 280E, pushing a very aggressive interpretation of 280E. saying that if you're plant touching, you don't get to deduct anything except your cost of goods sold. And that's a very harsh result with respect to the retail side. It's a less harsh result with respect to producers. Shall I just stop there?
No, you can keep going.
Okay. So the tax court has decided against the taxpayer 6 cases in a row, and the 6th was called Harborside. And Harborside is this big dispensary in Oakland, and the 2 guys who founded Harborside are like cannabis icons, and they wanted to found a dispensary that was the gold standard. Their books and records are perfect. Everything is a closed system. Everything. They made sure that no cannabis leaks out of the system to non-medical use, all that sort of stuff. And the IRS said, well, we're going to disallow all of your expenses except costs of goods sold. And there was a tax court case that was decided late last year, and it went against Harborside on every single issue that Harborside raised. Rachel and I went to Harborside and said, you really got screwed in tax court, and you should hire somebody else to do the Ninth Circuit appeal, like maybe an actual boring corporate tax lawyer instead of a cannabis lawyer. And Harborside did that, and so we're arguing this appeal. And I just want to say one other thing about the state of 280E. The IRS thinks it's settled because it's won all these cases, but actually case number 7 came out of the tax court last week. It's a really interesting case. I just want to tell you briefly about it. The case is called Northern California Small Business Assistance versus Commissioner. There's a business that could have used some branding help from some of the people here. It's kind of a silly name. Anyhow, standard dispensary case. There are 2 weird things about it that are really interesting. One is it's a reviewed tax court case, which means the tax court took it upon itself to have the entire tax court, all 14 judges, look at the case and write opinions. That's very interesting, and it shows that in the tax court there's some internal dissent about 280E. That's very interesting. And their views are not the same as the IRS. And the way that comes out, this is where it gets really interesting, is there are 3 dissenting opinions. And the 3 dissenting opinions say that 280E is unconstitutional, which is amazing. They say it's unconstitutional for 2 reasons. One is that it violates the 16th Amendment, which is the income tax amendment. They say because you disallow all of your expenses, it's really not a tax on income. It's a tax on gross receipts. So that's a really interesting holding. The second, they said that 280E violates the 8th Amendment to the Constitution. Now, if you don't recall what the 8th Amendment is, it says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The tax court judges, like 3 of them, said 280E constitutes an excessive fine under the 8th Amendment. That's really interesting and amazing. So what those judges are saying to people who are litigating future cases, and that would be us, is that there's an invitation to raise the constitutional grounds against 280E, and we're thinking about it. I'll just add one more thing. Needless to say, I don't think a lot about the 8th Amendment in my everyday boring corporate tax practice, so we're reaching out to various people who do think deep thoughts about the Constitution and tax law. And fortunately, I went to Harvard Law School, so I'm calling up my professors there and saying, what do you make of this? So I guess my bottom line is 280E is kind of unsettled, which is not a lot of help to people who are trying to make a living in it, but that is what's going on.
I'm just curious about the history of the sort of constitutional arguments that have been made previously. Weren't there some constitutional arguments raised in the previous cases to some extent? And then how did the court treat those? I mean, why does the IRS feel so emboldened now?
First of all, I can't recall seeing an 8th Amendment argument being made. I just can't. There have been due process arguments that I don't think are very good. And the 16th Amendment arguments in previous cases were, they weren't really very good either. And because they didn't come from the tax law. This dissent starts off with what is cost of goods sold? And cost of goods sold is what takes you from a gross receipts tax to real income tax. And it's saying that by disallowing all these expenses, you really are not having a real income tax. And that's a very tax-centric argument. And those aren't the arguments that were made before. That's what's really interesting about this opinion.
I just while we're talking about cases, I want to just mention too, alternative healthcare, which is a case that came out isn't that after Harborside? Yeah, which was kind of unique as well because of the way it treated, or the court treated management companies, which I think this is a very important issue for a lot of businesses, because I know in a lot of states there's going to be management service providers, there's going to be affiliated entities affiliated with the licensed entities. So James, I know we didn't talk about this, but what should businesses look out for when it comes to affiliated entities? What did the court do in that case? Could you educate us a little bit?
Sure. In alternative healthcare, the tax court agreed with the IRS. Alternative healthcare had one corporation, and then had an affiliate corporation provide management services. And the IRS contended, the tax court agreed, that your entire unitary business enterprise is selling cannabis. Your entire unitary business enterprise is thus subject to the 280E disallowance. So it sort of casts a lot of doubt on the management service agreement strategy. Generally speaking, the concrete advice that we want to give to people is that keep really good books and records. You need to keep really detailed books and records. So depending on what the law says, you can allocate different things to the cost of goods sold. Also, with respect to management services agreements and separations of entities, to make the argument there that some of your entities are in different trades or businesses and not plant touching, you need to have actual real live legal contracts, preferably reviewed by real live lawyers, because a lot of times in the cannabis world, and I've only learned this in the last year, business is done on a handshake. Well, that doesn't help when it comes to the tax law. So put everything on paper and have it all at arm's length terms.
Yeah, I mean, I think alternative healthcare was really interesting because there was some argument that the management company didn't have title to the marijuana, but the IRS or the tax court didn't care in this case and still found that they had, and the language was, a unified business purpose with a single profit motive. So it really was not a very good opinion for the industry because a lot of companies are set up like that. Dana, just going back to you, do banks care about IRS tax compliance? Do they care about books and records, and what kind of books and records are important for your compliancy program?
Well, we take a look at the past tax records and tax filings, but we do not really pay attention to the IRS tax code 280E at all. That's not something that would affect our decision to bank or not bank a business.
Right. No, I think there's a lot of uncertainty too, and there's a lot of that's up to interpretation, obviously, as to whether you're 280E compliant or not. But what about books and records? What kind of books and records are you looking for in a business in order for them to meet the standards that the banking compliancy program has?
The due diligence process can be quite daunting and extensive in the fact that we really uncover every stone. We take a look at all of the officers of the company, their background, their history, negative news, the company itself, the investors, where's the money coming from. So if you're an equity firm and you are doing a capital raise from investors, we need to know all of those investors take a look at all of that. So typical due diligence can take anywhere from 5 days to a month to get an account open. So I get calls every day, I need an account today. Well, you're not going to get an account today.
Right,
It takes
so-
longer than that just to fill out the application.
Right, and the applications, I don't know how many of you have looked at them, but they're pretty substantive. And then you obviously have to know your customers, so you can't necessarily trust the word on the page. We were talking before this panel started about how you actually go out to the cannabis businesses. And can you kind of explain what that looks like when you're going out to audit a business for banking purposes?
We go out to do an on-site visit, whether it's a cultivation or a dispensary or oftentimes even a doctor's office, to see how their security is, how they handle their cash, what their employees are doing with, how their normal day-to-day business operations are. We take note of all of that.
Yeah, I mean, handling many IRS audits of cannabis businesses, I will say that just like the bank, the IRS really cares about cash controls and inventory controls and making sure that marijuana or money isn't walking out the back door. It's very important.
We monitor every transaction at every location every day.
Good to know. I have a question because I'm just curious about this. Safe banking passed very recently, bipartisan support. Everybody's really excited about this. But what does it change, both in the near future, but also long term? Is this going to be a sea change?
Well, once it passes, the language in the Safe Banking Act is literally just putting those financial institutions that have a cannabis banking program at ease from prosecution. And that's one of the risks, and that is why a lot of financial institutions do not start a cannabis banking program, is because of the risk of being prosecuted. The Safe Banking Act will make us all feel a little bit more at ease. Again, we are still under strict guidelines by, the regulators, us in particular, the OCC. They do pay attention to every little transaction. Where did the money come from? Where is it going? And why?
So really, the day that SAFE passes the Senate, it's not like Bank of America is going to be opening up accounts the next day. It's
No.
probably going to take a significant amount of time.
It's going to take a long time because the risk is still there, and to build a compliant banking program is daunting and expensive, and a lot of financial institutions do not know where to start. And the larger national banks like Chase or Wells Fargo, they would have to train multiple employees at multiple branches, and it would just be cost prohibitive.
And it's probably going to take a long time to draft the regulations to implement safe banking. So
Right. So even if it were to pass in the next session in the Senate, it'll be a good 3 to 4 years before anything is acted on it.
but we'll probably maybe see some of the smaller banks, do you think?
Smaller banks are getting a little more comfortable with the risk. It's education of the board of directors and the executives.
So in Colorado and a lot of states that have been unbanked or underbanked for a number of years, Colorado's marijuana market is 10 years old, the legal licensed marijuana market. We have a big problem with what I call legacy cash. So this is all the cash that is stuffed in a vault somewhere under somebody's mattress, buried in various places in Colorado or other states. So what does SAFE change a bank's ability to take legacy cash, or is there any banks these days that are willing to deal with legacy cash?
The Safe Banking Act isn't going to change anything in regards to legacy cash, and banks don't want to touch that legacy cash because it's undocumented, it's unvalidated, and for all we know, it came from black market money.
Good point. All right, so I would like to get some practical advice, James, for our business owners So we haven't seen a lot of tax law-based or Section 471 specific arguments being made in these cases. What is the right interpretation of the statute, and how should businesses really be keeping books of records? Can you give us any practical tips?
Sure. This goes to cost of goods sold for a retail business. And what you need to do is not just keep your normal books and records, but also figure out and keep books and records regarding the time your employees spend on processing inventory and buying inventory, which goes into cost of goods sold, as opposed to the retail side, the front side of the store. And it's really helpful if a business has a job description for different jobs. The job description says, okay, you spend 40% of your time at the front of the store, but 60% of the time at the back of the store, where you process and record and do all the other stuff with the cannabis. That's really, really helpful. Also, you should keep floor plans so you can show, okay, this percentage of my store was dedicated to, getting the inventory in and processing it, as opposed to this percentage of the store was like the retail counters and where the bud tenders were. You need to keep that kind of stuff on a contemporaneous basis, so when you're audited, you can show that the numbers you were using came out of real records from that time.
So the IRS current guidance says Section 471, right? So you have to, your cost of goods sold in 471 are what's important. Are there any arguments that haven't been made in tax court regarding 471? I would say yes. James and I talk about this all the time. I think there are a lot of arguments that maybe haven't been made. And one of the things that James brought up is business records, and at least having a basis for your allocations, which I think is really important. A lot of people think that retailers are just totally screwed. And the Harborside case maybe didn't help us either. But things like what the IRS has said, they have issued guidance, at least on Category 1 and Category 3 costs, which you guys may not know about. So can you say there's anything else that's left to be said in some of these cases? I imagine I know this answer.
Yes, I think one of the issues with the tax court cases to date is that they didn't really talk about cost of goods sold in the context of the way it's been developed in the tax law, in the context of the way it comes out of GAAP. So basically everything, if you have a dispensary, you can't just order cannabis online and have it show up at the back door, right? You have to have somebody who's calling around and getting it, that kind of thing. That should go into cost of goods sold, but there's no written guidance to that effect. And the current IRS interpretation of cost of goods sold seems to exclude that, but that's clearly wrong. That's not that is at odds with the actual case law under cost of goods sold.
Yeah, they do talk about product procurement costs in the current guidance, but they don't go further than that to sort of explain what exactly that is. And from a practical standpoint, 280E, they talk about this sort of concept broadly as to what you can put into cost of goods sold, but there's a lot of nuance there that I think is yet unexplored, especially in our tax court cases. So I think we have, how many minutes left? 10 minutes left. I really would like to open it up for questions. So does anybody have any questions about some of the things we've talked about, or sort of Harborside, or what's being developed? Oh, come on, don't be shy. Yes, go ahead. I would say if you're not buying or selling, the problem with the alternative healthcare case, at least in my view, is sort of the degree of connection between the plant touching entity and this management services company, which had common ownership, right? They were both commonly owned. Basically, it was used sort of as this vehicle to move profits into another company that wasn't plant touching. And I think the rule of thumb is you cannot take what is otherwise non-deductible as a general matter, although this is very nuanced, and then put it into, put those expenses into another company and then make it deductible. So for example, and then again, it has to make business sense. I always say it has to make sense. Would a normal business carry on with like this? So I think there's been probably a lot of misguidance in the industry to just sort of create ancillary companies in an effort to sort of move the economics around, not only for 280E purposes, but also for regulatory purposes, where you have significant restrictions on how you can operate your cannabis business, nonprofit being one of them, but also maybe because of 280E and the punitive tax treatment that a lot of these businesses have. James, do you have more to, yeah.
But if your business in and of itself doesn't touch the plant, that's okay.
Yeah, and if you're only just providing a service, so lawyers are an example. We're just providing a service. I don't think there's any way that the IRS could come in and be like, now you're subject to 280E. Because remember, the issue is trafficking. Are you trafficking, meaning buying or selling, engaging in commerce of a Schedule I or Schedule II controlled substance? So if you're not doing that, I don't really see how the IRS could really hold you accountable. Now, management companies that are commonly owned, or for example, branding companies. And this is where it really comes down to the devil is in the details. That's what I think is really important. Having those agreements. I don't know how many businesses I speak to that say, oh, well, we license our brand and we pay the royalty fee back to this other company that might have similar ownership. Well, if you don't have an actual contract that states that, that's going to be a hard case to maybe prove if you get audited. And I always say it's not if you get audited, it's when you get audited. So just something to think about. These things, an ounce of prevention, a pound of cure. If you put a little bit of time and effort and energy and money into setting it up really correctly, arm's length contracts, doing it for real, it makes business sense. I think there's a lot to be said there. Another question.
For a firm that is applying for a license in Florida under the old it does not address either 280 or 1%. However, given the critical nature of it to operation, do they very early
Well, I'm not familiar with the Florida application, but what I can say is that as more states get legal, states need to address the 280E issue. Because remember, most states just follow that little taxable income line on the federal return. So they're going to tax you, even if it's legal in your state, based on whatever your federal return says. And a number of states have realized this after the fact, after they went and legalized cannabis, and then cannabis businesses were saying, well, wait a second, why are you punishing me for 280E? That's a federal provision. That shouldn't be happening. So states have actually had to pass legislation, California being one of them. I believe there was a recent state, Ohio or something like that. Colorado did it. We didn't figure it out for a couple years. And unfortunately, there was a much higher rate of taxes, but it's called the marijuana business deduction, at least in Colorado, so I think these are things that states need to be considerate of. So I don't know if it's in the application process, but when you're talking to your legislators, when they're passing regulations, somebody should be speaking up and saying, hey, let's make sure that we're going to be taxed fairly too. Florida might be an anomaly because you guys don't pay income tax, right? So that might be a little different. So, yes.
That's a very sophisticated question. why don't you come up to me afterwards and give me your card? No, I mean, no. There have been a bunch of articles written about this. As I'm sure you know, the 199A deduction is a deduction for people who own their own firm. And some people have said, well, 280E bars somebody who owns a cannabis firm and it's an LLC from taking the 199A deduction. But that's not true. And there have been a lot of articles written saying it's not true. If you give me your card, I'll send some of them to you. But lots of accountants right off the bat said, oh, no, you don't get it. But that's wrong. So. The reason the 199A deduction is good for people who own cannabis firms is that since it comes off of qualified business income, which is artificially inflated by the disallowance of deductions under 280E, because that's higher, your deduction under 199A is higher. Now that doesn't get rid of the pain, but kind of eases it just a little.
I think cannabis businesses and business owners can take everything they can get. I think we have time for one more question.
How much? Okay. How much support can be made to justifiably allocate your commercial property casualty insurance expenses as a cannabis business owner to cost of goods sold?
Well, I mean, I can tell you from a practical standpoint, just in the examination stage of IRS audits of cannabis businesses. First of all, there's like wildly inconsistent treatment. I don't think that. I mean, I've had cases where the examiner comes in and disallows all packaging, for example, which is clearly a cost of goods sold, but then allow in the same audit, and this is true, all your legal fees or all your accounting fees, which is really bizarre. So I think you have to take a position, and the position has to make sense. I don't know if you want to talk about the regulations at all in category 1, 2, or 3. No, James is done. But yes, it's you have to have good records, and you have to have a position. Now that doesn't mean that they'll accept it all the time, and usually you're going to get the worst treatment ever in the examination stage of an audit. I will say it's worth taking those cases to the informal appeals process. It might be worth taking it to tax court depending on what the cost-benefit analysis is and the facts of your case. Some of the cases I think that have been litigated maybe didn't have the greatest facts for our industry. So we have to be careful.
Right. The point is, one of the points is, go ahead and take the position. Right. Have your books and records, write up why you think that's so, and go ahead and do that. I mean, you have no downside from that at all.
That's true. I think, are we out of time, or do we have time for another question? We have 1 minute left. Do you guys have any other questions about either Harborside or 280E? I told you this was going to be very, very exciting and interesting. Anything else about banking? No? All right, guys. Well, I'm going to call it there.